Hello and welcome to the second of our Q&A POCA events hosted by 18 St John Street and Inquesta Forensic Accountants. My name's Andy Evans. I'm a barrister at 18 St John Street. In a moment I'll introduce my co-host Rob Miller of Inquesta Forensic Accountants. The protocol for today, for those of you that didn't join us last time, this is our second live Q&A session hosted over Microsoft Teams live events. It's a live event and therefore you'll be able to view slides and presenters, but you will not appear on screen or be heard. So feel free to take a deep breath and relax. Please use the Q&A button to interact with our producer Stuart, who will pass questions on to us. This is a closed chat and cannot be seen by other attendees until the questions are passed to the floor. The slides will be made upon available on request to chambers. We hope that you find this session useful. Please let us know via the chat box and come along to our next two sessions. Thursday is at 4:30, where we will be dealing next week with Section 22 reopening, and the week after that with historic benefit figure based upon assumptions. Whilst we've set this session as half an hour, we intend to have questions in the second half and will be available for 10 to 15 minutes at the end. Without further ado, I'd like to introduce my co-host, Rob Miller.
Good afternoon, everybody, and welcome to the second POCA webinar. Hidden assets is a favourite topic of mine, so I hope you all enjoy it. And I just want to say that please, as Andy said, please do put questions in the Q&A box. We will do our best to answer them, and if we run over a little, we are happy to stay on. Thanks.
I'll move on then and begin our presentation on hidden assets. Where does hidden assets come from? With the seminar last week, Tainted Gift, I was able to show you all the statutory definition of a tainted gift. That doesn't exist for hidden assets. How is a hidden asset defined in the Act? It is not. I downloaded all 960 pages of it today, so you don't have to. And the phrase is simply not there. Instead, it's this bedrock theory of POCA, Section 7. Section 7 defines the recoverable amount as an amount equal to the defendant's benefit for the conduct concerned, unless the defendant can show otherwise. We very rarely mine down to this bedrock of POCA, but it appears that the intention of the statute was that you set a benefit figure and then it's for the defendant to show that he shouldn't have to pay the entire amount. That's pretty chilling. The bedrock of confiscation proceedings is then that the benefit figure is set based on a number of legal fictions, and somehow it's the burden upon the respondent to prove he shouldn't have to pay all of that money. That doesn't often happen, of course. Most Section 16 statements, all of them in my experience, will come with the prosecution's case on available amount already set out, so you don't have to argue every pound and penny. But when hidden assets is concerned, the statutory backdrop of it must be that if there are assets out there that would be part of the benefit figure that can't be found, the prosecution is entitled to say for any or even all of the benefit figure that they are hidden. And once opened as a concept, the Court of Appeal is very clear. The burden shifts, you'll see from the statute, onto the respondent to disprove it. Essentially, he must show the judge that he doesn't have the hidden asset that represents the benefit figure. A reverse burden to prove a negative. That's why everyone loves responding to hidden assets. Is it really a reverse burden? Yes, it is. Here's some 15-year-old dicta in a case called Barnum. Barnum submitted to the Court of Appeal that stating that his benefit figure was the same as his available amount. I'll just quickly run through that, an example of that as an idea. Your benefit figure is set using any and all legal fictions, £150,000. Your available amount is a much smaller amount, possibly even nothing. And the financial investigator simply says, well, the rest of it must all be hidden. So we're going to make the 150 that the benefit figure was the same for available amount, 100% order. And Barnum said to do that was a breach of his human rights because where the Crown alleged that he had hidden assets, they had to, in his submission, make out a prima facie case before he could be expected to deal with such an allegation. Lord Justice Gage said no. He said once the prosecution has established the benefit, there is no requirement upon it to provide a prima facie case. The burden of proof shifts to the defendant to establish, if he can, his real asset, reasonable assets to the satisfaction of the court. By the second stage, he will know exactly how the courts determined the benefit, and he must prove by evidence what his realisable assets are. It is for him to show why the confiscation order should not be, and that the value of his proceeds of drug trafficking goes back to the old Drug Trafficking Act and the act that came before POCA. If he proves that he had no or appreciably less realisable assets than the amount of the benefit determined, the order will be made in a lesser sum. So Lord Justice Gage there in 2005 basically saying the prosecution are more than entitled to say absolutely nothing on hidden assets and leave it for the respondent to prove. Again, using the public interest argument to justify this. To do anything other would be to defeat the object of the legislation. We've heard this all before. It is designed to enable the court to confiscate a criminal's ill-gotten gains. Hidden assets is indicative of the fact that the prosecution can have no means of knowing how and where he may have dealt with or disposed of the proceeds of his criminal activities. So does that mean the respondent should move to block off the possibility of hidden assets in every single case? Well, in theory, perhaps yes, but in practice, of course, the prosecution usually includes the raising of hidden assets within their section 16. It'll be clearly set out. The prosecution say this is a hidden assets case. They should also include a valuation of the hidden asset itself, rather than just everything that lies between what we found and the total amount of the benefit figure, and a basis for why they submit hidden assets should exist. There were clear connections to a foreign country. There were clear evidence of money being stored elsewhere, buried in the garden or whatever. They should do all this, but of course from the law there's no obligation for them to do so. Rob and I have frequently seen that benefit figure is 100,000 and the available amount must also be 100,000 purely on the basis of hidden assets. And financial investigators often cite a case called Telly, 2008. In Telly, the defendant simply didn't disclose anything about his hidden assets at all, and the Court of Appeal found he hadn't satisfied the court that the total value of his recoverable amount was anything less than the benefit figure. So any shortfall was, by operation of statute, the available amount. It's a long way to fall because Mr. Telly ended up with a 100% benefit figure order. So there we are. It's a very, at this point, bleak picture. There's a reverse burden to prove a negative, and the price of failure is being saddled with a giant benefit figure as an available amount, and consequently that flowing directly to an unpayable recoverable amount, which leads to a gigantic time in default that will never be dealt with. It's a very gloomy picture. But we're here to explain today that you don't need to accept it. There are ways to fight back. The benefit figure does not equal your profit. It's usually quite easy to prove the benefit figure is not available. The benefit figure, of course, is based on a number of legal fictions. There's no apportionment available post the decision in Ahmad and Fields. Paragraph 23 of WIRE precludes you, when setting the benefit figure, of going into, well, my overheads were X, I had to pay Mr. Z this. Benefit figure is purely based on turnover, but available isn't, and you can fight. There'll be much more from that from Rob in a moment. But from this emerges a tactic, one I think of trying to establish a middle ground, somewhere between the financial investigators, it's all hidden, judge, go ahead and order the benefit figure is available, and your client who will generally say, I've got no hidden assets anywhere. In fact, I've got absolutely nothing. I've put there the case of Glaves. In Glaves, it was decided that failure to account for a hidden asset to the satisfaction of the judge does not require a finding that the recoverable amount should be 100% of the benefit figure. This was said it was an element of the evidence that the judge wasn't satisfied that the reverse burden had been defeated by the respondent, but it wasn't necessarily determinative. A court is entitled, despite rejecting the defendant's account on hidden assets, to make either a lower finding on hidden assets, that being lower than 100% of the benefit figure, or none at all. That's the tactic of the middle ground. The financial investigator says 100%, your client says 0, but there must be some middle ground because, quite simply, the benefit figure can never all lie in the hands of one person. It's based on too many legal fictions. So if a failure to account at all doesn't lead to the order where your available amount is the same as the benefit figure, maybe it's not so hopeless after all. I'm going to introduce Rob back to tell you how to fight back.
Quite right, Andy. All is not lost. We all know hidden assets are very difficult to defend, but as Andy says, more often than not, it does involve trying to prove a negative, and i.e. that they don't exist. I find that the hidden asset concept is one that is sound in the sense that it's there to recover the proceeds of crime which have been stashed away. However, it's often used as a tool to increase the available amount and the eventual confiscation figure. As forensic accountants, this tends to be the area where we can add the most value. So there's 3 or 4 typical hidden asset cases that we tend to see. First is money that's been transferred to a foreign jurisdiction, cash that's been withdrawn from bank accounts that no one knows the destination of, assets, physical assets that have been stolen but they haven't been recovered, and then the sort of the overriding, and no disrespect to any of the prosecutors in this webinar, we do sometimes see the lazy section 16 where the whole of the benefit is deemed to be the available amount. I'm sure we have all seen those where the FI that did the initial trial wasn't happy with the sentence that the defendant got and uses POCA to try and get them a default sentence for justice purposes. So question is, where do you start with these type of cases? The biggest thing that I will always highlight is, first thing to start with is the benefit. As it used to be the case that people to some extent ignored the benefit and concentrated on the available amount because that's what needed paying. Nowadays, with reopenings, the benefit is even more important. But on a hidden assets case, the benefit is the most important, especially when the available assets equal the benefits. So it's important, rather than to try and prove that he doesn't have the hidden assets, i.e. the negative, how about concentrating on reducing what the prosecution says he has got from his crimes? So, for example, as Andy said, on a drugs case, the particular benefit will be the value of the drugs or the value of drugs that have been seized. However, we all know that in that case, there must be costs involved in that enterprise. There's costs of purchasing the drugs, there must be the cost of the couriers, all that sort of stuff. And, you know, it's entirely appropriate when you're talking about available amount to consider what the profits of the enterprise are, or the actual gains, because you can't hide something that you've never had. That makes no sense at all. If the value of the drugs is based on those that have been seized, then he can't possibly have had that money because the drugs haven't been sold because they've seized them. So how can that be a hidden asset? Unexplained assets can, in my opinion, can rarely be a hidden asset because they're there for everybody to see. So if you've got a load of unexplained credits in the assumptions, you know, I would go out there very strong when the benefit's equaling the available amount, because they're there, they're in the accounts. There are certain circumstances, for example, when cash has been withdrawn or money's been transferred from those unexplained credits, but the credits themselves are in the bank account and cannot, by definition, be hidden. The same goes for property held. It's very rare that could be a hidden asset because it's a physical property that the defendants held within the last 6 years. The other thing to consider as well is, if it's, for example, a theft case, consider whether the money has been recovered, because the full value of the theft will be included in a particular benefit. But actually, if money has been recovered, then he can't have that. It can't be hidden. So just to add a final point on this slide, going back to what Andy said, that hidden assets don't have to be all or nothing. There can be a middle ground with these. So it is important to come up with a valuation of the hidden assets, even if your client doesn't like it. But I think Andy may touch on that a little bit more later.
Thanks, Rob. That takes me neatly on to what to do with actual clients. Clients are terrified by hidden assets, more so perhaps even than a lifestyle finding, because they know that this is really the sharp end. If they will be aware that a hidden assets finding can lead to a gigantic time in default that will never be repaid. What to do about dishonest clients, and what to do about this all or nothing approach? There's a run of cases here, Kelly, McIntosh, Lee, Yu, and Brooks, in which the Court of Appeal set out clearly how to deal with a respondent who is found to be lying. In Kelly, they stated that it was always for the respondent to show that there were no hidden assets, and mere assertions unsupported by evidence were always unlikely to suffice, which makes sense. However, in McIntosh and Marsden, the Court of Appeal stated that I think there's a microphone on somewhere. Where the prosecution allege hidden assets and the judge finds that the respondent has been untruthful, so when there's actually a finding of untruthfulness, whilst it will be difficult to discharge the burden placed upon him, it is not impossible, and that the judge was directed to consider other sources of evidence apart from the respondent himself to persuade a court that the assets available to him are less than the value of the benefit. This, I see, is precisely where a solicitor can help with the number of papers that they can produce to assist the respondent, but also a forensic accountant can help in lowering that. Just because you have a client who is potentially being convicted by a jury or is just going to be seen by a judge, bearing in mind it's often the first time the judge gets to clap eyes on him as a tribunal of fact as an outright liar, does not, on the authority of McIntosh and Marsden, mean that you should give up on fighting a hidden asset. Because, of course, if you do give up, the time in default will rapidly shoot up. Lee is a case in which, as Lord Justice Hughes said at paragraph 21, that it may be a legitimate conclusion for the judge to reach that the defendant has hidden assets, but not as much as the statute calculates as benefit. So merely because the judge doesn't believe him doesn't necessarily mean the only conclusion is the amount of hidden assets is the full amount of the benefit. This might well be instruction from the Court of Appeal to start fighting. Fight these, put your client up, even though he's an outright liar, because the judge may try to choose some lesser ground. And I have had this in the past with judges who say, I do not want to make a full 100% benefit figure order. Give me a middle ground figure. Now, that presumably is not the instructions of the financial investigator, because he'll be pushing for 100%, nor the instructions of the client, because he'll be pushing for 0. But there is definitely leeway within the Court of Appeal authorities for us to be pressing for lesser figures. I would suggest that not more than figure to try and narrow the argument and, of course, narrow the drop in terms of time of default. In U is the opposite of Lee. The judge did feel he had to disbelieve them, and then he jumped directly to a full order. And in that case, there's nothing wrong with that if the evidence dictates that that's the position. In Brooks, the Irish Navy seized a yacht with 1,500 kilos of cocaine on it. The judge came to the conclusion that there was £3 million worth of drugs, £3.6 million worth of property. Brooks contested it. The judge said that the defendant had left no financial trail for his dealings. He disbelieved him completely. And it's a little bit long to go into here, but when the defendant appealed, it was found on the facts that, and I quote Lord Justice Tracy at paragraph 30, the judge moved too precipitately from a rejection of the defendant's evidence to including the value of the drugs in the available amount. Even where the defendant was an outright liar, even when there were huge amounts of money kicking around and he only accepted £300,000, the judge moved too swiftly in going directly to a hidden assets finding of £3 million. So there is a good example there of how they should be cautious and how there is a good argument for trying to find a middle ground. This is a case I dealt with where my client's instructions were the exact opposite. Rob's identified 3 different types of hidden assets. The particular asset hidden asset, the stolen property. Rob's going to deal with the where are the drug profits hidden asset and the where is the cash hidden asset in a moment. But this was where is the stolen property. This was a theft from his employer. He pleaded guilty to theft of over £5 million of cash, paintings and artworks. He was the butler. Some was recovered and returned, but 3 artworks remained outstanding. Each one represented a hidden asset, said the Crown, and the total valuation they put on it was £1.1 million. The client's instructions, somewhat unhelpfully, were I never stole them, despite having pleaded guilty to it. So that placed us in quite a hole to start with. He then changed his version and said I stole them and destroyed them. Either way, I realised very quickly that he faced about 7 or 8 years in default with a £1.1 million hidden asset. He was never going to persuade the judge that he didn't have them. Specifically because the others had been recovered from a lockup garage in France that the police happened upon by accident. It was absolutely plain he'd hidden these. So what could we possibly do to avoid the long drop 8 years in default? Well, worried about an all or nothing decision by the judge, we fought valuation to try and find a middle ground. The client desperately wanted to have his say, so we did call him. We fought hard on time in default, but the biggest thing we did was revaluing the hidden asset itself, the £1.1 million valuation on the paintings was actually put in by a family member of the victim. The police were quite happy to go with this because she was in the art trade. When we had them properly valued, they were actually worth half that. You'll see, despite the fact the gentleman went down in flames because the judge failed to accept that he'd taken a real Picasso and a real Toulouse-Lautrec and set fire to them in a French ditch, the available amount, in fact, was only half of what the prosecution contended for because we fought valuation. We gave the judge some form of middle ground that wasn't 100% of what the Crown valued it as, but equally we knew we were never going to win because of our liar of a client who just wanted his day in court. I'm going to pass back to Rob for dealing with the where are the drug profits hidden asset.
Okay, so I just want to apologise. My internet's glitching like mad, and it's very in and out. So if you can't hear me, and if I disappear, Andy, can you just take over from me, please? I'll keep talking for now. So this is a case that I worked on fairly recently. It was a drug case. The guy was from Albania. The particular benefit was 2.5 million, which was the value of the drugs. He had unexplained credits of 223,000, property held of 100,000, and expenditure of around about 79,000. This is an example of what I call the lazy FI. Ultimately, they put the whole available amount as the benefit figure, which is quite clearly wrong. We did a full analysis of this guy's bank accounts, and they were pretty clean. There was no money that had been withdrawn. It had all been paid on genuine expenses. There was no money that had been transferred to Albania, but because this guy came from Albania and had some family out there, the prosecution decided that he's got all his money stashed out there, and it's clearly wrong, and there's quite a lot of work to do on this. So again, this goes back to what I was saying earlier. Step one, look at the benefit and try and reduce that, which we did, because the unexplained credits couldn't be hidden assets, the property held couldn't be, nor could the expenditure. But it's also worth looking at. We're trying to identify the source of the property held and the expenditure as well, so you can try and reduce the benefit as it is. I mean, is it correct to include the assumptions in the hidden assets?
Rob, we can hear you okay. Plainly a bit of a problem with the internet at Rob's end there. He was just explaining how one of the ways in which you can tackle this is to try and take on what it is said to be a hidden asset. And I think with the drugs profits ones, there is an issue here where Wire dictates to us that we cannot tackle benefit figure on the grounds of hidden assets, but on the grounds of turnover. What we must not do, says Wire, is try and go in and say, I paid this money to the Dutch border force to look the other way. I paid this much money out in bribes. That's for benefit figure alone. I believe that when you're dealing with available amount, bearing in mind it's a completely separate calculation, it's entirely right to take this sort of accounting-based, profit-based approach, because what you're asked to do when they allege hidden assets as a benefit figure is explain where is the money you took. And the answer is that money never actually passed to me in the first place. So it's a viable argument to go into this sort of profit and loss accounting when you're looking at benefit, explaining where the benefit figure went, even though there is dicta to suggest it's inappropriate to do it when tackling the benefit figure in the first place. Rob, are you able to rejoin us?
Yes, I'm back for now until I get kicked off again. Yes, so I think the point with this one is, we're trying to prove a negative, which is obviously difficult. Can I have the next slide, please? Okay, so this case is an example of where cash has been withdrawn. So this was a fairly straightforward benefit fraud valued at around about 20 to 30k. But unfortunately, the unexplained credits came out at 250k, and the hidden assets figure was the same. So the argument on this one, the defendant's evidence was that when he came to the country, he was told to open a numerous bank accounts, withdraw cash from one and deposit it into another on a regular basis to build up his credit rating. And it was plain to see from the bank analysis that what he'd done, he had drawn money from one account and he had deposited it into another account. The issue here comes when they withdraw from one bank account, spend some of it on their living expenditure, put that in a drawer at home, and then withdraw some more and then bank it at a later date when it's built up. And experience tells me that, unfortunately, the prosecution doesn't tend to accept that argument unless you can clearly see the money going in and out of the same amount at exactly the same time. So we had to go through the bank accounts. We had to look at all the trends of the money moving in and out of the bank accounts and try and prove that actually it's quite obvious what's happened here, because the money hasn't been spent. So what they'd done is they'd include all the deposits as unexplained credits, and they'd included all the cash withdrawals as hidden assets. This is the only case I've ever had, I shouldn't say this, where I actually got a letter of thank you from the defendant, because we did a good job to ensure that actually they removed the hidden assets assumption. So these things that we can do work on these and actually get good results. It's also another point to note is that it's also worth looking at lifestyle, because if a load of money has been withdrawn, it's worth looking at the bank accounts to see how much they've actually spent on their living expenses, and if there are obvious gaps in those bank accounts that the defendant hasn't paid for any gas for 3 years, then the likelihood is he's going down to the post office and paying for it in cash on tokens or whatever it may be. You can also look at the ONS living cost survey as well, and you could look at a couple with 3 children and see what the average expenditure for those families are, and compare the expenditure that's come out of the bank accounts to the ONS surveys, and often that can reduce the hidden assets figure, because you are able to show that actually some of this cash must have been spent on general living expenditure. Okay. Andy, you're muted, I think.
Thanks. I agree with that approach, because it's just an evolution of the approach I was discussing when you dropped off. The idea that if the prosecution alleged that the full benefit still rests with your client as an available amount, whether that's generated from drugs or thievery or money laundering, simply money moving around, the obvious response is, well, nobody keeps 100% of what they take. And whether that money's gone on the operation of the criminal enterprise or the operation of a real enterprise, maybe they're running a cover business, or just on general family expenditure, these are all solid arguments to explain to a court why the benefit figure no longer rests in the hands of the respondent. I'm going to very briefly deal with a case on reopening hidden assets. In Pearson, there was an application to, under Section 23, reopen the available amount by the defendant. It is incredibly tricky for the defendant to reopen a hidden asset. What the court said was that it is possible to challenge a hidden asset, but of course the burden of proof lay upon him. To my eye, if it's already been decided against you at the earlier hearing and you've managed to lose the argument, you're very unlikely to win it again. However, in this case, on the facts, something quite interesting happened. This was a good example of where the prosecution contended for a high figure, the respondent contended for a low figure, and the judge stated that there was not less than £50,000 in hidden assets lurking in Bulgaria, according to the Court of Appeal. A good example of them finding a middle ground. Judges do not want to be going for gigantic pie-in-the-sky figures and consequent times in default. They would rather find a middle ground figure. So although Pearson is an example of how not to, or how it is very difficult to reopen one of these, the facts of it are a very useful framework as to how a judge could approach one of these orders where the two parties are so very far apart. I think there were some, we've thought of a few questions. I think Rob was going to pose the first to me, if we can. Rob, you're on mute.
I'm back now. Just before we go on to that, one thing I wanted to add that I missed when my internet was glitching is that, you know, it is important to differentiate between the benefit and available amounts, because there is so much at stake with hidden assets, and it can result in such a significant default sentence. So they should always be defended and not just accepted. And there is always work that we can do on these. There's also the negotiation point to consider as well. There may be no hidden assets, but if the prosecution are not giving in and are intent on continuing with the hidden assets argument, the defendant may have to pay something to avoid going to prison. So there is a damage limitation exercise as well to be done. So Andy, the first question to you, is it ever worth the risk of calling your clients?
Well, happily, Rob, you've already answered that, because what we just said is that fight the benefit figure. One of the good ways of avoiding 100% benefit figure available assets, the hidden asset growing to match the benefit figures, if you fight the benefit figure down as well. Sometimes your client can have very useful evidence to give on the benefit figure, or at least you shouldn't be accepting what the prosecution have to say on the benefit figure. All the case law I've set out earlier in the presentation shows that just because your client does give evidence and is disbelieved doesn't necessarily mean the judge has to make 100% benefit figure order. He doesn't need to give the large hidden asset. So in those circumstances, the drop is far less. And therefore, it is often the right move to call your client, but also be backed up with a middle ground, presumably something prepared by an accountant or prepared at least by the instructing solicitors to set out what the hidden asset is no less than, in the language of Pearson. It's all to do with challenging the pie in the sky figure that the prosecution may stand at, which is the 100% benefit figure. Rob, my question to you, where do you begin to challenge that 100% figure when the section 16 comes in and says he's got the lot?
Well, I think we've covered most of that in this talk, but just in summary, it's worth saying, you know, as you say, start with the benefit figure, try and reduce that. Definitely worth looking at and focusing on how much the defendant has actually received from their crimes, not just take it as read that the particular benefit should be included as a hidden asset, because it's quite simply not the case. As you said at the beginning, the statute is not entirely clear on hidden assets, and therefore there is plenty to go at. It's also, as I said previously, it's worth looking at the lifestyle point, worth looking at where any cash withdrawn has gone to, what it's been spent on. And again, remember, unexplained credits, property held and expenditure can rarely be included as a hidden asset, and they will be my first port of call. Should we just move on to, there is a question that's just come through on the Q&A. Do you want to, should we take that one out? I will put it to you, Andy, because I think it's one for you. It says, hidden assets initially alleged in the section 16, the defendant maintains that none were hidden and a property abroad had been lost as payments were not maintained. The FI concedes the property is likely to have been lost in the updated section 16 and do not pursue the hidden assets. At a contested hearing where the defendant wants to challenge the benefit figure alone, can the hidden assets still be found by the judge?
Theoretically, yes, the judge can find anything, but they should not do so unless they're invited to do it by the Crown, as I see it. And this actually goes to my question 3. What do you do when there is a middle ground between everybody? Everyone can see that. So I would submit that the best thing to do would be to put in a section 17 stating your position, which is there is no hidden asset. Hidden assets equals 0. That the section 16 should also say hidden assets equals 0. And I always advise in POCA that the best route before a POCA is to put in a Scotch schedule, whether you're before Judge Lever in Manchester or not. If you put on the Scotch schedule that there's no longer any issue between the party on hidden assets, it may not even ping up on the judge's radar. But all the dicta suggests the judge is entitled to take a route on hidden assets which isn't the route taken by the Crown and isn't the route taken by the respondent. However, on every single one of those cases, it's between the two. You've got the prosecution here, the defence here, and the judge goes down the middle. It would be very, very rare indeed for the prosecution and the defence to be together down here and the judge to come in right at the top. However, there is dicta to suggest that the judge's tribunal of fact can make whatever findings they want. Nevertheless, I think it would be in your client's best interests to go ahead and challenge the benefit figure, because, of course, an unchallenged benefit figure can lead to a reopening, which we will see next week. So on balance, the tactical approach would have to be go in, challenge the benefit figure and remind the judge that the parties are agreed on it. I don't know what you think of that, Rob.
No, I agree entirely with you. There's been another question that's come in, and it's a really good one. So I'm going to put it out there. It's from Melissa at Tucker's. Just disappeared off my screen for a second. So it says that DWP fraud and the client's pleaded to all counts. The Crown have accepted the client has no available assets, but have stated 300,000 hidden assets based on cash withdrawals over the relevant period. The client states he spent it all on gambling. Gambling records show 140,000 of money spent by my client. The client wants his day in court and wants to give evidence to say no hidden assets as the money is spent. Is it worth asking the Crown if they will accept 160k as the hidden asset figure? The client wants his day in court. We have no evidence other than the gambling records which show 140k spent. Crown accepts no lavish lifestyle, council house, and no cars, assets, etc. This is a brilliant question. Andy, I'll just start it off, but
go for
it to carry on with it. Okay, so it may be worth looking at the lifestyle point on this one, because if he has taken cash out, so there's 160,000 missing somewhere. It's quite obvious to see. He's saying he's got no hidden assets. It may be worth looking at it and try and reducing it a little bit further to try and identify if there is any other expenditure which potentially could have been paid in cash. Okay, we can't put physical evidence together, but if we can put a theory that actually there's clearly expenses missing from his bank accounts, potentially, when you look at what someone's normal living expenditure would be, there is an argument to put forward there. Having said that, and Andy will agree with me, if that isn't the case, it is definitely worth asking the Crown if they will accept 160k as the hidden asset figure. This is the middle ground that we were talking about earlier. So Andy, go for it.
Yeah, that's exactly the point. Is there any reason why your section 17 can't read that a hidden asset is zero, but on this evidence it can never be more than £160,000? Have a look at some of the case law I've put up, specifically Pearson, actually, where essentially the judge said it was never going to be more than X, and they didn't care what the prosecution had to say. Therefore, he can reject the prosecution's case, reject your case, and you still insulate your client against the possible big drop of the 100% order. So I believe it's appropriate to put in two positions in the section 17, one, your client's instructions, and two, on the maths, the maximum it can ever be. And when I say the maths, obviously assistance by a forensic accountant or someone doing Rob's role, as he's described it, will drag that £160,000 figure down further and further. But ride two horses. I don't see any reason why you shouldn't. We've got a new question. I can publish this one. I'm going to publish the top one. This is from Anonymous. When dealing with hidden assets and showing a lavish lifestyle while a husband and wife have spent the lot, could the wife who is not prosecuting then face money laundering proceedings? There is a rule in POCA that nothing in a section 17, so nothing coming from the defence, can be used in criminal prosecution. So if the wife was to state that they had spent the lot, they would not then be able to use that alone as evidence. However, they would be able to use it as intelligence and presumably be able to prove the case that you've already admitted. Therefore, as long as they don't use the actual documents that you've submitted on your respondent's behalf, they could therefore go for the other party in terms of money laundering proceedings, just out of spite. I don't see any reason why they couldn't. We've got one further question. Is a loan strictly classified as an asset in relation to defendant in a POCA proceeding? Rob, I'm going to take this one if you don't mind. Loans and assets. The definition of an available asset is section 7, any free property then in the defendant's hands, the plus any hidden assets. The only thing that is not there is an asset which is listed in the list on section 7, and it's very, very short. It's basically the statutory surcharge and any outstanding court fines. There's a lovely trick if you want to really annoy the financial investigator and your client's got about £1,000 in outstanding court fines. Statutorily, they can't be. They've got to be knocked off a POCA. But loans, party to party, specifically unsecured debts, still fall in the respondent's hands under section 7. The only argument you could have is that it is inappropriate, disproportionate, underwire, or unjust to take from him someone else's money. The reason that they do include mortgage advance or don't include mortgage advances in an available amount is usually because they just get the mortgage company suing them constantly, as far as I can see. So it depends on the nature of the loan, but yes, I think in general you can expect loans to fall as part of an available amount. Rob, one final question on our list. Just because the defendant has come from a foreign country, can the prosecution just assume he had assets hidden there?
Difficult question to answer, isn't it? I mean, ultimately, yes, they can. I think it would be fair if that was the only argument, that just because they came from a foreign country, they've got hidden assets. I think we could put some good arguments against it. I mean, for example, in the case I was talking about earlier, the solicitor actually went out to Albania and took pictures of the family out there and their living, where they were living, and he actually was able to give a witness statement himself to show that they're not living a lifestyle in Albania. Certainly not gone to his wife and family for their schooling or anything else. What's your view on that?
My view goes back to this concept that just because your client is foreign, or just because they're lying even, it doesn't mean that you can't use outside sources of evidence to make a decision that the hidden asset, that the benefit figure is not equal to the available amount. Fight everything. There is definitely a horrid undertone in this particular idea, you know, they're foreign, etc. But you do often see any money going out of the country. My case with the butler, he happened to have gone to France. Everybody else involved was English. But as soon as somebody crosses the borders, the suggestion that hidden assets come up is just it's a very basic understanding of hidden assets for the forensic investigator, sorry, financial investigator rather from the police. So this is just another example of just because your client is X doesn't mean you should accept these terribly large orders, or indeed any order. I think the flavour really we're getting is hidden assets orders can be absolutely gigantic. People do want to avoid them altogether, but the other way to do them is to tackle them head on. And Rob's just explained there how expert assistants can assist you in tackling prejudice, be it on the basis of your client's nationality or just on the basis that your client spent 7 weeks lying in front of the jury and the judge finally gets his teeth into him. That would be my take on that. If anyone else has any other questions they'd wish to pose, now is the time. I'm just going to briefly pop up our little advert for next week. Next week, we'll be dealing with Section 22 applications to reopen. They are very much in fashion now. They weren't 8 or 9 years ago. A lot of the advice people had on all POCAs was probably right at the time and is very much not right now. We're dealing with an awful lot of these. But I see there's no further questions, Your Honour. There's our details if you need to contact us. Thank you very much for joining us this evening. I hope it's not as wet where you are as it is where I am. And we will hopefully see you next time. It's goodbye from me, Andy Evans. It's goodbye from Rob Miller.
Goodbye from me. Thank you.